And in the view of the dissenting persons on this table, let's just establish the fact that, as you've referenced continuously, we are not a bench.
Yes,
obviously. But then again, there is the room for the expression of opinions on this. Or is there any uncertainty about the position of the law on this matter of when a Chief Justice is removed? Can she still serve as a Justice of the Superior Court?
There is no ambiguity at all. There is no doubt, all right, from all the cases so far, especially starting from Ejechu, where that matter was very much at play, that when a person is removed as a Chief Justice, that person loses the office of a Supreme Court judge as well. There's no doubt at all. Listen, let's go over this. Asante Bediatuo and his father went to court. Okay, they represented Ejechu. Let's go over the argument. Did read it? But let's read it again. Of course, when I was coming this morning, I wanted to read it because some lawyers are saying it's obita. When we say obita, so they are trying to say that it didn't concern those statements that the Supreme Court made. Were not necessary for resolving the case that Ejechu brought. So I mean that it was irrelevant. It's just that they were talking. I mean, just expounding law, but it's not relevant. Listen, they made their argument. They say the Constitution does not provide any separate and distinct grounds other than those set out in Article 1461 for removing the Chief Justice, qua Chief Justice, that's as Chief Justice from office. Thus, under the Constitution, a Chief Justice cannot be removed as a Chief Justice from office and remain on the bench as a Justice of the Superior Court. He can rather be removed from office on the same grounds as a Justice of the Superior Court and by implication lose his position as a Chief Justice. You see, they said, and by implication lose his position as a Chief Justice. And that's why Modibo Okran said, yes, what you are saying is right. And now you turn back and say, no, nobody asked the Supreme Court to make such determination. If you didn't put the argument there, would they be answering you? That was the argument that was made. ADG read it. We are reading for emphasis. You sent the argument there. Did anybody put a gun to Ejechu's head and his lawyers to make that argument? They thought it was relevant for the case, and so they made it. No. And then you come to what Dateban. So we read Modibo Okran. Dateban is the one who gave the lead opinion. So let's see what he says at that side. Let's come here. So Dateban says at page 775. Page 775. Let's go to the last paragraph. He says, as far as the Chief Justice is concerned, I think it is reasonable to link his conduct of his administrative responsibilities with his position as a justice of all the superior courts. So you see, that the bar says they are linked. Justices of the superior court are required to adhere by, maybe now we'll say to, certain judicial ethics, which can be infringed by the conduct of a Chief Justice. You see? So he said justices of the superior courts are required to adhere to certain judicial ethics, right? Which can be infringed by the conduct of a Chief Justice in the performance of his administrative acts. You see it? So that's it. So you are acting as Chief Justice, but certain conducts also affect your, what do you call it, conduct as a judge. And what do we say here? Here we've lost 367,000 Ghana cedis because Chief Justice signed for that money to be given to her husband and to be given to her daughter, the per diems and the tickets, all that. So we're saying it's illegal. In actual fact, what the the committee is saying is that there was no right whatsoever to take that money for the Chief Justice's family. This is very grievous. Look, we are even being very charitable. That's why I keep saying the more you push this point, then the more you would cause people to go and file criminal charges. Somebody will go and file. Yes.
How you talk about criminal?
Yes, criminal charges. Because the Chief Justice herself, the Chief Justice herself in the Abronyeh DC case, the presidential spouses, she said no. Article 71 is very clear. Wives of presidents and vice presidents cannot take money from our public purse. Not knowing at the time she had already taken some for her family. How? They are sitting in judgment over other people that no, Article 71 doesn't allow that money be paid to spouses of president, vice president. Meanwhile, by then you are taking money for your spouse and children, a child. I mean, it's ridiculous. So this, let's not push it. The more you push it, the more ridiculous. And look, I have people sending me messages that viewers are very angry that, look, we are pushing this argument too far. We are pushing it too far. How can you say that a bar is showing you that in your conduct as Chief Justice, there are certain things you do which also affect your ethics as a Supreme Court judge? So you see how it's linked. It's a consolidated process. So if you come to the facts of this case, we have lost what? 367,000. Who asked that the money be paid for the tickets and for the spouse and for the daughter? This is not child's play. And let's nail the final fact. Look, millions of our citizens don't earn even 100,000 the whole year. And you have one family just blowing this in 2 weeks or less, and you think this is a child's play. Where? No, let me land. Where? So show me. Is that so? The constitutional matter is that. Can you show me there? Is it in the Wando report, or is it in the Aremeyaw Anas report, or Green Street report, which says that when the Chief Justice is traveling, they should pay spouses per diem, pay children per diem? That's a very grave constitutional matter that people want to play politics is. Where in the various reports from Green Street on listen, Aremeyaw Anas, Wando, etc. Which of the reports say that you can pay the spouse of the Chief Justice any per diem, or pay the child of the Chief Justice any per diem? When in actual fact, the Chief Justice herself in the Abronyeh and then Dafia Meko, those cases, had said that you can't do such a thing. So let's stop playing with this and they're making very arid arguments that go and start afresh to remove her as a Supreme Court judge. When the Supreme Court itself is saying that the two are interlinked, it's a consolidated process. It's farcical, very, very farcical to say that we should go and start from scratch and remove her separate. That a bar says your ethics, things you do as a Chief Justice, also affect you as a Supreme Court judge. So it's one combined process. You are removed as a Chief Justice. You are also removed, ipso facto, as a Supreme Court judge. Let's not toy, because like as I say, viewers, the lay people are not having it easy. That some of these things, yes, I know there's devil's advocate, but please, when the law is clear, let's not do these arid arguments.
She is back in court. In fact, this is the seventh, but the first application after her removal, challenging her removal as a justice of the Supreme Court, not as Chief Justice, a justice of the Supreme Court. Because in their view, the president does not have the power to take her off in these two, but for the Chief Justice, yes, but not the justice of the Supreme Court. She's challenging that and stated a number of reliefs that she's asking that the courts consider. This position as espoused in this particular latest application from the former Chief Justice is reflected in some statements that she made in that press conference she addressed during the period of the process for her removal. And this is it. Take a look.
Every step of the removal process being undertaken against me is being done in a manner that breaks every rule on how justice is delivered in our country. And this is why I find the need to draw the nation's attention to the serious violations of the Constitution and law in the process, and the danger it holds for the development of the nation's democracy. Unfortunately, every step of the removal process being undertaken against me is being done in a manner that breaks every rule on how justice is delivered in our country. And this is why I find the need to draw the nation's attention to the serious violations of the Constitution and law in the process, and the danger it holds for the development of the nation's democracy. Unfortunately, every step of the removal process being undertaken against me is being done in a manner that breaks every rule on how justice is delivered in our country. And this is why I find the need to draw the nation's attention to the serious violations of the Constitution and law in the process, and the danger it holds for the development of the nation's democracy.
That's the former Chief Justice, Justice Gertrude Araba Esaba Saki Torkornoo. These are the reliefs that she's seeking. A declaration that the president is devoid of power to remove a justice of the Superior Court from office without recourse to the mandatory procedure set out in Article 146 of the 1992 Constitution. She goes on further to detail exactly which part of Article 146 that applies in this instance of the relief that she's asking for. That there should be a declaration that jurisdiction to hear a petition for the removal of a justice of the Superior Court from office lies with a body properly constituted under Article 146(4) of the 1992 Constitution of the Republic of Ghana. We'll look at the dictates of Article 146(4). So stay with us. Also, a declaration that the warrant of removal executed by the President dated 1st September 2025 purporting to remove her, in this case, she, the applicant, herein from both the office of the Chief Justice and the office of a Justice of the Superior Court of Judicature is unlawful, null, void, and of no effect. Essentially that this warrant of her removal executed by the President cannot have the extension of its powers to cover the removal of a justice of a Superior Court of Judicature. Because bear in mind, the Chief Justice served 2 roles. And even prior to her removal, this conversation about if she is removed, can she still serve as a Justice of the Supreme Court is one that was rife. This warrant of her removal, as was issued or executed by the President, brought that matter to rest. And this is what she's challenging, essentially. We'll put it on the screen. This is the warrant that she mentions in her relief. Now, therefore, know ye all men that I, John Dramani Mahama, President of the Republic of Ghana, in pursuance of the said Article 1469, do hereby remove the said Chief Justice, Justice Gertrude Araba Esaba Saki Torkornoo, from the office of Chief Justice and Justice of the Supreme Court. So this warrant, the powers of it applied to the 2 offices that she held with immediate effect, in witness whereof I have hereunto set my hand and caused the presidential seal to be affixed at Accra this 1st September 2025. Akufo Bento, now start off with you on this. I mean, look at the demands that have been made in this relief, and I'm mindful of the limitations that we have in discussing this matter. But references have been made to past cases and the fact that aspects of the relief being sought for has already been dealt with. Does this position or the argument being espoused have the potency to alter the power of this warrant of the president, removing her as Chief Justice and also a Justice of the Supreme Court?
Right. So when you say whether something has the power to alter something, you know, we are in deep law here. And let me just...
The law is the law.
Oh, yeah, the law is the law, but honestly, it is not that obvious all the time. Yeah. So,
let me, forgive me, let me acknowledge the presence of Christian Mamhesi. He's a private legal practitioner as well. This is the table of lawyers this morning. Counsel, good morning.
Now, at least you have engineer, right?
Yes. At least now I feel that I'm now beginning to feel, you know.
Thank you.
So,
thank you. Welcome. Great, Mr. Bento.
Right. So, lawyers will say there's something which is void, ab initio, and then there's something which is voidable. So, President has done something. The lawyers will tell you, if you do something, or again, they will say you can't put something on nothing. If you do something which you don't have the authority to do, it is void ab initio. It never had power. And sometimes, given who you are as a terror, and even sometimes based on ignorance of the people it affects, people don't know that it's void, they will carry it on until somebody realizes that it is void, and then they void it, so it's voidable. Now, question therefore is there anything here that can be said to be void or voidable? That brings another thing into, you know, sharp relief. And we need to understand this fundamental principle. I've been saying it all week, that in a constitutional republic, nothing is final until the justices of the land make a pronouncement on it. Unless the person decides not to take it up for judicial pronouncement or the statute of limitation runs. So you can elect a president, and the justices of the Supreme Court can sit and say that election was void. So nothing is final. That's point number two. Void or voidable, and the finality unless there's a judicial pronouncement. Then the question is there a cause? All right? We say any fool can go to court. But the question is, will you win? Is there a cause? Is there any leg upon which somebody or something can stand? And to this extent, please, we all, first lawyers, and second the rest of the nation, have to appreciate that look. If there is room for us to expand the frontiers of law, justice, and freedom, we should never foreclose on those things. Let the process be gone through. Let every facility be exhausted, and then we can proceed. Why? There's a difference between a legal constitutional process and a political process. And we've been making the mistake in this Fourth Republic of making legal constitutional processes political processes. To the extent that when we embark on those things, the last time I was here, I call it railroading. You put the person on the railroad, the rail will determine where they will end, regardless of what the law says. It's wrong. And I'm telling you, when you have a situation where legal processes are made into political processes, you go straight to become a banana republic. It's happening in other countries now where the justices don't have any say. The president says something and then they just come and rubber stamp it. We lawyers know the case of Marbury and Madison. And why that is important for the rest of the public is this. When some people in their power do something, even where they believe it is right, okay, in another case where there was the Marbury and Madison situation, the justices of the Supreme Court sat down and went beyond what those people had done, stopped it, and did what was right. And therefore seized power to determine finally how things may be done. I'm saying all these things because I hear people talk about, oh, Madam Torkornoo, why is she still struggling? Why does she want to come back? Why is she's disgracing herself? And I got into trouble when I said that some of these emotive, okay, suggestions and unsolicited advice and all those things, they don't help expand the frontiers of law. So let me come to the substantive issue now. It is in the Constitution that there's a separate process for appointing a justice of the Supreme Court. And there's a separate process for appointing the Chief Justice, who is the Supreme Justice of the Supreme Court. 2, there is a separate process for removing the Chief Justice. And there's a separate process for removing a justice of the Supreme Court. One is CJ, one is JSC. Okay? And so on and so forth. There's a reason why these things are there.
The oath taking.
Yes, the oath, you go for a different, parliament, everything. Look, it is not for nothing. Okay? Now, and there is a lacuna. There is a situation where that determination has not been emphatically made. My brother here, Martin, and I don't have to tell you I respect Martin. He's my lawyer and I'm his lawyer. But when we disagree, it's on principle.
Yeah.
Earlier on, we were on radio, and afterwards, we're still discussing the matter. This whole week.
We discussed it.
We keep talking. But the point is that he sent me something which was extremely persuasive. I read it, and then later I read. Then I realized that that section that he sent me, which said those things, were obiter. And again, I said we are in hard law, so please permit us. It wasn't a ratio. So when you have a case in court, there is what is called a ratio decidendi. The main reasons why the decision is made the way it is made. And then after that main decision, there are other things that are said around the issue. What causes or creates a precedence which is binding on other courts is the ratio decidendi. It's the ratio. However, the obiter has persuasive effect, but it is not precedent creating. So I pointed out to my brother Martin that, look, somebody in the ratio had said that, oh, if you remove Chief Justice, then hey, you have removed this one. Okay?
Yes.
Yeah.
Because he referenced decided cases, on this particular matter.
That is why I'm going through ratio and this thing.
Yes.
That, you see, that case, somebody made a passing remark. And it's obiter. Obiter does not create precedents. Let me explain to you why. When a case is before the court, the justices go into the merits of that case. They don't examine other things as much as they examine what is called the issues. So in ratio, the issues are dealt with. But obiter, it is said in passing. And many times, obiter makes sense. Because they say, hey, if they remove your Chief Justice, then they've removed, they have this. So. And the person was trying to say that, look, it is a serious matter, so please, be careful how you deal with it. Because once the person is removed as this, it could mean that they are removed as this. And let me also make the last point before I go into another matter. When they say somebody may do something, or an action may lead to something, in law, it also means that action may not lead to that thing. May swings both ways. Okay, we have to do all these things now because we need to understand that when you have these kinds of situations where they are not clear, let the law be gone through. Justice Torkornoo is saying something simple. He's saying...
Are you going to the next point? Because
I'm going to the next point, yes. I'm going to the Constitution itself.
Describe Justice Mahamadu Tanko's...
Let me finish this point, please. I beg you.
In this particular issue, because then...
I beg you, I can't think about that now. Let me finish this point. Only this point.
Yes.
There is a separate process for removing a superior court judge. The composition of the committee that removes a superior court judge is different from the composition that removes a Supreme Court judge. So the point is being made that even though we have all been thinking that, oh, this knocks out this, one bullet kills two things, one stone kills two birds, it is not so. And the framers of the Constitution did not design it as such. So please, at the least, if a reason takes out the Supreme Court justice, okay, which comes through a separate committee, Constitution Committee, that reason cannot take out the Chief Justice, clearly, because a different committee has to be set to deal with that. In the same way, if that different committee sets, and if you permit me, I'll read it. It's in 146. A different committee set to remove the Chief Justice. A different committee has to be set. And if they like, they can take those same reasons and go through that process also to remove the person as a justice of the Supreme Court. There is a case there. There is a point there.
Okay, so 1464 is what you referenced. I'm going to put that on the screen right now. So are you saying that in this Frank Agyapong case, which has actually been the reference point for this entire process and why the Chief Justice cannot serve as a Justice of the Superior Court after being removed as Chief Justice is an arbiter in meaning?
Yes.
And so does not necessarily apply in whole?
Yes.
That in the reasoning of Justice Amadou Tanko, that, quote, I have arrived at the conclusion that this application must fail without relish, mindful of the fact that the applicant, the Honorable Lady Chief Justice of the Republic, is going through a process that may define her career on the bench as Chief Justice and as a judge of the Supreme Court or the Superior Court. Then there's also this Agyapong case as well, where Dateba also gave what you would call the lead opinion of the Supreme Court, and Justice Ofori Akufo actually concurred in that regard. And you're saying all of this are arbiter and cannot apply in whole?
So my colleagues here will tell you that, yes, Justice Tanko's statement was arbiter, and he said, we need to be careful when we are dealing with this, because it may define her career as a Justice of the Supreme Court and maybe lead to the removal. And I've explained that when somebody says it may define her career, it is true that it will actually define her career. If you are moved from here to there, it puts a certain mark on you. But if you say it may also affect her as a Justice of the Supreme Court, it also means it may not affect her as a Justice of the Supreme Court. So we are being careful here. And the last time I said we need to be very sober about some of these things. If we don't like the Constitution as it is, do what Martin Kpebu did, or whoever. Go make a case and let's get an amendment. But we have a situation where the thing is written there, it has the force of law, it is what we are living our lives by, which is why I make the distinction between a political process and a legal process. If we go by the legal process, the law is the law. And we have to have fidelity to the law. You don't agree with it, amend it. But if it is what is there, do what the law says. And the law says you can't remove a Justice of the Supreme Court unless by a certain specific process. And to that extent, look, there are many other things, okay, which this occasion may give rise for us to look at them again and go deeper into them. For instance, this whole issue about prima facie, which Agyapong dealt with, okay, I have read and I have here the testimony of Nana Dr. S.K.B. Asante. And he has made it emphatically clear that that prima facie requirement is so fundamental and so crucial that if it is not respected, the whole process is null and void. He used the term, it is fatal to the process. These are serious, and it's not me. This is Nana Susubibi, KB Asante. All right? Gentlemen, we are trying to
say.
I can give it to you if you want. But
in the report of the Committee of Experts for the Constitution.
This is his witness statement, okay?
Okay.
And it's here.
Okay.
Okay, and I'm saying, don't take my word. Nation building is a slow, but has to be a deliberate process.
Okay.
And you know about ad hominem approaches. You look at somebody, you like or don't like the person, so you approach in a certain way. And I'm saying, a political process, by Edwidge and Co., and Edwidge wears two hats. When he's doing his politics, different. When he's doing his law, different. Yeah. Tomorrow, these same things will be applied somewhere. We missed an opportunity in Charlotte's case. If we had been more careful and gone about it the way I am suggesting now, a bit more deliberate and stop looking at the politics and the politicians of that time who railroaded Charlotte, okay, we may have arrived at a different conclusion here and may have been a bit more careful. So, if you say Nana Susubibi says, Dr. S.K.B. Asante says that the original process was fatal. What it means is it was void ab initio.
On what grounds?
On the grounds that the prima facie requirements were not gone into. So, because of time.
Yeah. But the Supreme Court says, the Supreme Court says failure to give reasons for a prima facie doesn't make the case void. That's Chachu Chikete's case.
Okay.
Over 20 years ago, 2003, 2004 Supreme Court. Chachu Chikete went to the Supreme Court that the failure of the trial to give reasons for saying that there's a prima facie case, so he should open his defense, makes the case void. The Supreme Court said, no. It just
but
means
that's too far. Republic versus Michael Asamoah.
Are we talking about the removal of a chief justice?
No, I'm just talking about prima facie, criminal, liberty.
Yes.
Hold on.
Let me make my point.
See,
So, let the justices who are more experienced than us and have the actual office to do this, take these matters, go in chambers, deliberate, and then come and tell us finally how we proceed on this. Because if Nana Susubribi says that absent a prima facie determination of the Council of State...
Was it absent?
Wait, let me finish.
Yes, yeah.
Because you see, when you say something is present, but it is only with you, it must be give the person the thing. No, wait. Was she given that?
That's the reason. She was given communication that there is prima, but no explanation.
So, you see, what we are doing is why this matter should go to the justices. Yeah, you're not getting me. My point is, we can't agree on this. And I'm saying, a very serious person is saying, not doing that is fatal.
No,
so I'm simply saying,
said otherwise. It's not what SKB Asante says.
Well, you are not hearing my point. Is the fact that we disagree is the reason why it must go before them.
The law has been clear that if you fail to give reasons, it just shows you are biased, you are thoughtless, there's malice.
Okay, so
that's what the Supreme Court said. So you can make those allegations.
Dr. SKB Asante says that it is this. And I'm saying you are clear in your mind it is not so. Unfortunately, this is not a Supreme Court bench.
The Supreme Court has pronounced twice on failure to give...
What would be the implication of the removed Chief Justice still sitting on the bench as a Justice of the Superior Court because of what led to her removal? That is stated misbehavior. She's been removed as Chief Justice, then she's still sitting on the bench as a Superior Court judge.
I don't understand what you mean by what would be the implication. The person has been a judge for over 20 years, risen to the topmost office. 21 years. Yeah.
Some say 20.
To the topmost office. Okay. Now, she is elevated to perform additional administrative duties. Has nothing to do with her competence and experience as a judge. In other words, she is not in any way incapacitated from performing her duties as a judge. Now, during the performance of her administrative duties, the persons in charge of accounting, the heads of finance and whatever it is, approved for her to do something which previous chief justices had been doing. And she did it.
But that doesn't make it right.
Let me answer the question, please. I'm not saying it's right or wrong. I'm simply saying that something like this happens. The only institution in this country which is legally mandated in our constitution, the Auditor General's Department, audited that action, raised questions, and the questions were answered. In their final report, they took that issue out and published the final report that this is not an issue. In previous situations where it has happened, it never was an issue. In other situations where similar things have happened, the highest punishment was a refund. And it was not something that goes to the heart of the performance of her duties as a judge. And the matter had been rested. Then a committee which does not have the same level of authority and expertise as the whole Auditor General's Department resurrects the settled matter, uses it, even though it is not judicial and does not go to her competence as a judge, to remove her as Chief Justice.
Well,
wait, let me answer your question.
Yes.
I just need to explain to arrive, and I hope, I'm rushing. So, in answering your question, there is no impediment to her continuing to perform her duties as a justice of the Supreme Court. But the issue is, what would the optics be like? And I'm saying optics are not law.
Okay.
Optics are not law. But if that is what we want, let's change the law. But today, as it stands, there is a cause for Chief Justice Torkornoo to make the points that she's making. So let it be a legal process, not a political process. If there are opportunities in the law to expand this further, let us go through it and let things fall where they may.
So,
but let us not foreclose it.
By all means, there has to be some declaration on this.
There
But
has to be,
I
for our
asked a
future
question-
sake.
Right. I asked a question premised on Article 128 because you referenced the fact that to the extent that, yes, she has been removed as Chief Justice, but then again, that power does not extend to her removal as a Justice of the Superior Court. I referenced the basis for her removal, that is stated misbehavior. You say optics is not law.
Yes.
But let's reference what the law says in 1284,
Yes.
specific to who qualifies to be appointed as a Justice of the Supreme Court. A person shall not be qualified for the appointment as a Justice of the Supreme Court unless he is of high, and in this case he or she, is of high moral character and proven integrity, and is of not less than 15 years standing as a lawyer and so on. The emphasis is on high moral character and proven integrity.
Yeah.
To the extent that she was removed on the basis of stated misbehavior, that she still qualify to satisfy the requirement of high moral character and proven integrity.
In my view, that was never proven because the fundamental issue itself, I would have no surprise if Chief Justice Torkornoo challenges that original decision. So to that extent that it could be challenged, and like I've said, it's not final until it is pronounced on. So to the extent that there is doubt there, then her integrity has not been challenged. That is number one. Number two, 128 is about appointment. It's about how you get into the office. Again, law is law. There is a separate process for appointment and separate requirements for appointment. When you jump that hurdle, you've jumped it. And then there's a separate process for removal. All right? This has to do with how you get in. She's already gotten in. She has achieved it. She's passed this test. And you cannot now use this test for her removal. And if the removal, assuming without admitting, that proved that she didn't have whatever high moral, it still is not grounds for removal.
It's still grounds for
It's
removal?
not ground for removal.
Why is that?
The removal has to go through the process. And when the process is gone through and they have arrived at that conclusion, it is after that conclusion that then we have those grounds. And I'm saying, to the extent that it is still not final, because I said I wouldn't be surprised if Chief Justice Torkornoo, and I've told you because of what Nana Susubibi, Asante and Co have said, that determination itself, the composition and other things, may challenge that. Okay? So, until that is final, it is not final. And let us not use 128. Because at this point, we are using removal processes. Okay? Now, when she's removed, we've already talked about the fact that she can remove as CJ.
Yes.
Because that's administrative on top of those things. There is the other issue of whether she's also removed as JSC.
Yes, I reference 128 in the context that she's been removed as a Justice of the Supreme Court.
Yes.
And she's seeking that that power be quashed, essentially, because it's null and void of no effect. So she is reinstating that position that she deserves to be a Justice of the Supreme Court. I reference this based on the qualities that a Justice of the Supreme Court should have as enshrined in the Constitution.
Yeah.
And the basis for her removal. You say that has not been proven.
And what I'm saying is that if even you say so, and it is not so because I don't know, but I think that could be challenged, the removal process must be gone through. So, for instance, with all due respect, if you catch her doing something, which on the face of it, okay, renders her unfit to be a Chief Justice, you don't say, oh, I caught her doing ABC, and because of that, you still go through the process, bring those facts down, and let them be adjudicated, and then the decision will be made. I hope you're getting me. So there is substantive justice, there's procedural justice. I think what we're talking about here is procedural justice. That the fact that you think, that is why even when we catch somebody stealing, the person is not locked up until you take them through a criminal trial. So, in short, I'm saying it still does not open that door. And that door is a door for removal. And the removal requires that a certain process be gone through. Me, Kofi Bento, what I am simply saying is, I want the process to be gone through.
True.
Because I see a situation where we are using political processes to railroad people and just simply applying the law as a vehicle. And I don't think it is good. We've seen it during Charlotte's time when Samson brought this matter there. If we had been careful to look at it and go through things and come out with some of these things. And by the way, 296 applies in some of these things also. You know, we need to expand the law and make it clearer. Okay? And let's take this opportunity to do so. I have said and I repeat, what Justice Torkornoo is doing is to our benefit as a country more than to her benefit as an individual. And I think we must have the patience to allow her to exhaust all her remedies, so, whether you like her or not.
Right. But so by all means, no matter how anyone feels about the disposition of the removed Chief Justice, to the extent that this removal of a sitting Chief Justice is unprecedented, all such applications for clarity in the position of Kofi Bento must be encouraged so that there's a finality on the matter, because in his position, all references to pronouncements of this particular relief that the Chief Justice is seeking, or the removed Chief Justice is seeking, are arbitrary, to say the least. Does not necessarily create solid precedents to raise questions about the reliefs that she's seeking in her application. Why do you hold a different view?
Okay, so once again, I think that we are just going in circle. The Chief Justice herself now removed, appreciates what the law is. At this point, all that she's engaged in is what the lawyers would call forum shopping.
Why do you describe that forum shopping?
Look, every aspect of this matter, she's gotten one way or the other a court to pronounce on it. It is her dissatisfaction with the judicial pronouncement that she's running around with. First of all, and I've always maintained, there's nothing new under this sun. My senior Bento talks about obiter. I don't know exactly what he's referring to. Frank Agyapong's decision is extremely comprehensive. If you look at the law report itself, it has the more detailed portion of it than what we have in soft. This is what, may he so rest in peace, Justice Modibo Okran had to say in the Frank Agyapong decision in concurring.
I think we have that. We'll put that on the screen right now.
He says, quote, with no such gap filling, one is left with only Article 1461. And since the removal of the Chief Justice of Ghana from office is pegged to the same set of grounds as any other Supreme Court judge, the Chief Justice, upon removal, will, by implication, also lose his position as a judge. As unfortunate as the consequence will be for our hypothetical judicial brain turned disastrous administrator, I would have to agree with the plaintiff's position. That's not an obiter. That's ratio. But that also makes me wary of any interpretation of Article 1466 that will make it easier to remove the Chief Justice on courts. So that is clear without ambiguity.
And do you have the plaintiff's position to read?
No, I'm coming. I'll come.
Just read what
hold on.
Wait.
Because do you know why? At that time, Brata Kwete wanted Chief Justice Akwa removed.
Yeah.
And that is what caused, what shall I say, Frank Agyapong to intervene at the Supreme Court. Not only did he want him removed as the Chief Justice, he also wanted him removed as a Justice of the Superior Court. Do you know why? Because the Supreme Court, in reading Article 1281, what does it say? Let me just read Article 1281. And it brings everything into proper perspective. It says, quote, the Supreme Court shall consist of the Chief Justice and not less than 9 other justices of the Supreme. So she is first and foremost a justice of the Supreme Court and a Chief Justice. It is not all. It's not disjoint. So that you will say that she is a Chief Justice, Chief Justice. No. She is first a justice of, and so if you read Article 128, you can put it out there. Article 1281. It says, quote, the Supreme Court shall consist of the Chief Justice and not less than 9 other. 9 other. Because what it means is that she has the same characteristic as the other 9 judges. That's what it is. And so once you are removed, your umbilical cord, the cord, is completely taken, detached.
But if that's the case, why does the Constitution specifically state the process for the
I'm coming there.
You should have read this one.
Please.
It says may only be removed.
Please,
no. When you read it,
senior.
this is the Constitution.
Wait.
1462. It says
first of all, nobody reads constitutional text in isolation.
No, but that does not be removed from office except on shall not be.
So wait. You see when you were submitting for good reasons,
it should be done as a whole.
So I'm coming there.
Without this,
so I'm coming there.
Hold on.
I'm coming there.
1462.
In Frank Agyapong, the court, hold on.
Very strong.
The court,
we'll reference 1462.
Yes.
This is what hold on.
The Agyapong decision was not a cavalier decision. The court construed other constitutional provisions. And in a very interesting manner, even imported provisions just to make meaning of the Constitution. Why? The issue of prima facie was never an attachment relative to that of a Chief Justice. Yes. My Lord Justice Databa then said, quote, because she is also a Supreme Court judge, if in the case of a Supreme Court judge you are making a prima facie, then attach the same thing to her. Is it not in the reasoning?
And go through the process.
So how suddenly you are creating a constitutional dissonance?
And go through the process.
You don't do that in doing interpretation.
Okay, hold on.
Please hold on.
Why the reference to 1462?
May not.
A justice of the Superior Court of Judicature. Please hold on.
Yes.
Or a chairman of the regional tribunal may only be removed in accordance with the procedure specified in this article.
It is there.
And it is the reference.
Why are you doing this?
Hold on.
Senior.
Hold on.
First of all, you see, even this one came back under the attack. So if you read this provision, the Supreme Court's attention was drawn to this provision. And my Lord Databa said, listen, this one says that a justice of the Superior Court of Judicature, like any ordinary Supreme Court judge, High Court, Court of Appeal, should be removed by the procedure specified here.
Yes.
And this procedure includes the determination, prima facie determination. Then Databa said, look, when it comes to the Chief Justice, you don't find that expression relative to the Chief Justice.
Okay.
That is what got Dateba to say. That to the extent that the point I was making is that if you look at Article 128 of the Constitution, 128 says that the composition of the Supreme Court shall the Chief Justice and 9 other justices. So first of all, she is first seen as a judge of the Supreme Court, then a Chief Justice. So it is one and the same. It is just the performance. So when it comes to the Chief Justice, she has an elevated administrative role added to. And so if you look in the Agyapong decision, my Lord Justice Dateba then took the view that in reading 146, what you see is, it says, like you just showed, 1462.
Let's put that 146.
It says that a superior court judge and the chair of the regional tribunal may be removed in accordance with the procedure specified in this article. And the procedure includes a determination, a prima facie, and all of those things. You understand?
A different composition of a
Please hold on. Please calm down, step by step. So whereas 146, 1 and 2 says that unless in accordance with the procedure specified, that procedure includes the prima facie determination. However, when it comes to Chief Justice, it jumps and does not make any reference to prima facie determination. So when it got there, Justice Dateba then says no. Even though there's no specific reference of the word prima facie relative to that of the Chief Justice, because she is first a judge of the Superior Court before a Chief Justice, that process should apply. And that is how that mischief was cured in the Frank Agyapong decision.
Right.
It's instructive to note that if you read further the Frank Agyapong decision.
So that position cannot be described as an arbiter?
No. It was a main argument. And now I want to go back to the legal submission my senior Nana Asante Bediatuo made in the Agyapong decision. Because you will notice that in Agyapong, the argument Agyapong canvassed were agreed. It's what the Supreme Court finally brought finality to. Now, I want to read the argument that was made by the lawyer, Nana Asante Bediatuo. It reads in paragraph, it starts from paragraph 10. It said, because the Chief Justice is a judge and the chairman of the regional tribunal, the Constitution in its wisdom provides that the Chief Justice can only be removed from office on the same grounds as that of any other judge or the chairman of the regional tribunal, and it reads, quote, stated misbehavior, incompetence, grounds of inability. Now, 11, this is the argument. Thus, the Constitution makers by the expression shall not be removed from office except prohibits the removal of a justice of the Superior Court or Regional Tribunal from office on any ground other than the one stated in Article 146. A Chief Justice, now this is instructive, a Chief Justice being a justice of the Superior Court can only be removed from office on the ground set up in Article 1461 and no other ground.
And what are the grounds?
Now listen. So I'm coming. 146 deals with 1461 deals with stated misbehavior, incompetence, inability. And in the case of Torkornoo, she was removed on stated misbehavior. The argument on incompetence was rejected by the committee. Now, most importantly, 12. These are the arguments being put before the Supreme Court by Bediatuo. The Constitution does not provide any separate and distinct grounds other than those set out in Article 1461 for removing the Chief Justice, qua Chief Justice, from office. Thus, under the Constitution, a Chief Justice cannot be removed as a justice from office and remain on the bench as a justice of the Superior Court. he can rather be removed from office on the same ground as Justice of the Superior Court. Now listen to Justice Modibo Okran. In response to this beautiful argument by Bediatuo, he says, personally, I do not agree with you. It's unfortunate, but that is the law. And so,
that's what Professor Justice
Modibo Okran, may his soul rest in peace. In his reasoning,
that's what you say there. He said, as unfortunate as the consequences will be for our hypothetical judicial brain, turned disastrous administrator, I would have to agree with the plaintiff's position, but that also
the plaintiff position was canvassed by the lawyer Nana Asante Bediatuo.
He continues. That also makes me wary of any interpretation of Article 1466 that will make it so easy to remove the Chief Justice.
And so, you see, even at that time, there was some apprehension by the judges that it would be so easy to remove a Chief Justice.
Yes.
But the court said, look, this is what the plaintiff is saying.
Yes.
Regardless of our emotional attachment with whatever or sentiments, we believe this is the law.
What the plaintiff is saying is the law.
Yes, what the plaintiff is saying is the law.
The law is the law.
And agreed. So it cannot be suggested, even remotely on this platform, that was an obiter.
But I think
extremely. In fact, it would be completely disingenuous to do that. What is even instructive is the idea here that the view of Nana Asante Krobia, SKB, who was only a member of the Committee of Experts. The Committee of Experts did not write the Constitution. In fact, most of their proposals were rejected.
You're making a different argument, please.
No. What I'm saying is that
evidence to the committee. I'm not talking about his.
I agree. But what I'm even saying now, even at that time.
No, this is about his testimony to this.
Yeah, you are not getting my point. I'm saying that, you see, even what he's saying now was rejected. It is not sacrosanct. Yes. So the whole idea that the views expressed by way of his testimony carries more strength than. But you see, my Lord Justice Amadou Tanko, in the injunction application by Her Ladyship the Chief Justice, addressed this issue of prima facie determination and the absence of reasoning. Yes, in the injunction matter. You see, people are confusing two issues. There were different matters that came before the Supreme Court. There was one that she herself found.
Yes.
There was one by the civil society group, SAGES or something.
Yes, and then there is Vincent.
Exactly. So
Kwabena, that's the Civil Center for Elections or Censure.
Yes.
Censure. Now, you see, if you come to Justice Amadou Tanko's reasoning on the issue of whether or not the prima facie should be embedded. This is what he said, and I just want to read that portion. That's paragraph 43. He said, the next ground on which the applicant invites the court to restrain the committee is that the prima facie determination was not judicious, as it was rendered without reasons. I have cautioned myself against prejudicing the substantive relief sought in this action. However, it is not in doubt the applicant herself has acknowledged the existence of a prima facie determined, however described. Whether the form or contents of that prima facie determination rendered it nullity due to the allegation of absence of reasoning is a matter to be determined at the substantive hearing. Be that as it may, I am not oblivious of the jurisprudence from the court that a judgment rendered without reason is by all means a judgment. And then proceeded. Whilst it is the interest of justice that reasons accompany judicial or quasi-judicial outcome, there is no known jurisprudence in our court to the effect that a decision rendered without detailed reason is thereby a nullity. This holds especially true when the prima facie is said to have been made without reason, but which may merely requires adversary to present a defense. And in this case, she appeared before the committee and defended herself. In the relief that she is seeking by way of judicial relief, nowhere does she challenge the prima facie determination. She had moved on from that argument. Her argument now has to do with the fact that she detaches herself, the office of Chief Justice and that of a Justice of the Superior Court. And now says that to the extent that she had been removed as a Chief Justice, she remains as a Justice of the Superior Court. That is what you see in her relief. That is what you see in her relief, without more. So let it not be stated that A, B, C, D, because of that you cannot. My learned senior Kofi Bentele, making his submission, said, look, the matters raised in the petition are matters that were dealt with by the Auditor General, and for that matter, quote unquote, the committee cannot make a determination into it. More or less, they have become fontus with no power, more or less, to like a judicial review of the Auditor General's report, more or less. Please. I want to use one example. If you look at the Public Procurement Act, Senior, you will notice that Sections 1991 provides what you do when the allegation of breaches of the Procurement Act. You remember? It says that a committee, an investigative team shall be put together, investigate everything, and once the investigative team, the authority can recommend ratification. It can recommend rectification. It can actually recommend any of those. So I remember when the issue of Charlotte Osei came up, the argument some of us raised was that since the allegations do not deal with her work as electoral commissioner, electoral or the chairperson, and deals with borderline action, procurement, we should permit her to stay. Because then her function as a chairperson of the commission has not in any way been violated. The argument that were the resistance at that point was the fact that no, the procurement issues are antecedents. They come together with the office. And so if there's any allegation of breaches of same or violation of same, that constitutes stated misbehavior. I was in court the day Malik Kweku Baku and Samson Ladi, obviously being led by Samson Ladi Ayenene, came to court. What was their relief? One, that to the extent that the grounds of ABCD, they do not touch to the core function of the commissioner or chairperson. Two, that the absence of a CI to regulate the work of the committee renders the committee's work effectively a nullity. Two issues effectively. When it came up, the Attorney General then, the Deputy AG, Mr. Godfrey Adame, represented the AG in court that day. And some saying Mr. Kweku Baku. The court raised the issue of jurisdiction and asked, this matters in your relief. To what extent do they deal with constitutional interpretation under Article 2 of the Constitution? They asked lawyers to address them. I remember vividly the words of my Lord Justice Nene Amegache to Samson. He asked him, Counsel, are you saying a public officer who has violated the Procurement Act is not a stated misbehavior? In open court. And that is how the court ended up throwing.
What did the procurement authority say?
Please. Okay. At that time, there was no investigation. So our argument was that since the statute had provided a remedy, that remedy ought to have been followed first, concluded on the matter, and advised that this one you can't even do ratification. On that grounds, you can proceed to remove her. And so the petition to President Akufo Addo was premature. That was the argument. The court asked something. I remember vividly. My Lord Justice Nene Amegache. He asked him, what sayest thou? And that is how the court ended up dismissing, throwing away the suit Mr. Kweku brought to challenge the removal. It has also been suggested, and I'll maybe conclude on this, that absence a CI pursuant to Article 296 renders everything a nullity. That argument has been made. You see, thankfully, again, nothing new under the sun. When President Mahama pardoned the Muntie 3, my senior Eliklim Agbamava and senior Tuayebua issued separate rates at the Supreme Court. The Supreme Court consolidated it. My Lord Justice Bene rendered a judgment of the court. In one of the relief, they said, because Article 72 raises the issue the president may pardon, what it means is that it brings into sharp focus Article 296C. And since the president is not a judge, he ought to publish a CI to regulate. The same argument that has been made, that in making the prima facie determination, the president and the council of state, they not being judges, ought to have a CI to regulate. 2, that the president may suspend, pending the determination, the president exercises discretion, and so there ought to be a CI. This is how the Supreme Court resolved that matter in the Eliklim Agbamava and Attorney General. My Lord Justice Bennett then said, he said, when the decision maker is taking a decision in accordance with, in consultation with, there is no further requirement for a CI. And that the reason for that CI, pursuant to Article 296, is to cure the issue of arbitrariness and to ensure fairness. And so to the extent that in the Muntie 3, the decision to pardon is a decision flowing from consultation with the Council of State, the argument, be it colorful, attractive, that there ought to be a CI is without merit. And that is how that decision was rendered.
In fact, because
I find it extremely curious. Any argument founded on the ground that, one, there was no CI, so
yes,
she couldn't have
been. The GBA has
so I am dovetailing that conversation into it. Look, the Ghana Bar Association, with respect, the creme de la creme.
We'll get there.
Very well.
We still have things to say about this.
Thanks for watching. Like and share the video. You can also drop your comment. Please don't forget to subscribe. Click on the bell to turn on the notification.